This lecture is primarily for the members of this community, and well, kung may mga estudyante ako rito sa legal ethics, let's review na possible na lumabas dun sa midterms exams nyo. Mga basics lang naman to, so hindi kailangan mabigat yung discussion. So I'll just go over it and hopefully it helps sa review ninyo. Okay, let's start. Okay, this is legal ethics. We'll start first with the basic concepts. Okay, a definition of practice of law. Well, based on the case of Cayetano versus Monsod, practice of law means any activity in or out of court which requires the application of law, legal procedure, knowledge, training, and experience. So there's your keywords there: application of law, legal procedure, knowledge, training, and experience. Now, to engage in the practice of law is to perform those acts which are characteristics of the profession. Now, generally, practice of law is to give notice or render these kinds of service, which device or service requires the use of any degree of knowledge or skill. Now, based on the case of Cayetano versus Monsod, but ito yung naging sabi na nga natin nung discussion ng class. This is the basis of the current or existing definition of practice of law dun sa CPRA or sa CIPRA. Okay, what are the factors used to determine whether an act constitute a practice of law? Now, parang elements to. What constitutes or what are the elements of a practice of law? First, habituality. Second, compensation. Third, application of law, legal principles, practice or procedure, and attorney-client relationship. Habituality, anong ibig sabihin yan? First, well, if you have consistently represented yourself in public that you are a lawyer. Second, if you have received compensation from your client or anyone else or anyone from the service you have rendered. Third, application of law, legal principle, practice, or procedure. Or, if you use any of your knowledge na natutunan mo ng law school or wherever, or possibly YouTube University, then possibly there's a practice of law. Now, here's the clincher. The last one, attorney-client relationship. If there's an attorney-client relationship, there must be, or it must constitute a practice of law. Okay, next. Who may engage in the practice of law? First, well, members of the bar. And who are the members of the bar? Those who have completed or complied with the academic requirements, and those who have who have finished or have graduated their secondary education, law school, they obtained their Juris Doctors or LLBs, and they have passed the bar. And after they have passed the bar, they have signed the roll of the attorneys and took their oath as members of the bar. Another requirement is that he's a member of the bar, or he's a member of the bar in good and regular standing. It's based on Rule 138, Section 1 of the Rules of Court. Okay, this concept is one of the cornerstones of legal ethics. Practice of law is a privilege, not a right. Ang ibig sabihin, based on the case of Ke versus Attorney Revilla, it is not a natural, absolute, or constitutional right granted to everyone who demands it. Rather, it's a special privilege granted and continued only to those who demonstrate special fitness in intellectual attainment and in moral character. So based on that statement by the Supreme Court, those who have, well, intellectual attainment, ibig sabihin, those who have completed the educational requirement and passed the bar. And second, most important, moral character. It's a continuing requirement, the moral character of a person. Bakit? Dahil nga madali lang siyang mawala yung privilege of practicing law. Sabi nga dito, being a privilege, the practice of the legal profession is extended by the courts only to those who are qualified and deserving. So again, qualified and deserving. Those are your keywords, qualified and deserving. Sino yung mga qualified persons na yun? Those who have special fitness in intellectual attainment and in moral character. Okay? Now, Supreme Court further said that they may withdraw or deny the privilege who fails to respect and observe the lawyer's oath and the ethical conduct of his professional and private capacities. Okay? Next. Another cornerstone in legal ethics. Law is a profession, not a business or trade. Okay, in the case of Kine versus Simbilio, said that practice of law is a decent profession and not a money-making trade. Bakit? Compensation, in this case, should compensation should be but a mere incident. Okay, the primary consideration here is duty to the public and to serve the public and not money. Based on the case of Khan versus Simbilio. Now, one of the key concepts here in this, with regards to this cornerstone of, well, legal ethics is what? Solicitation. May solicitation. Solicitation, well, sabi rin on the same case, Khan versus Simbilio, it's not really prohibited by the Supreme Court. However, it is looked down upon. Actually, medyo hindi siya, it's teetering in the line of propriety. Okay? Sabi dito sa case na to, it must be compatible with the dignity of the legal profession, made in a modest and decorous manner, and that would bring no injury to the lawyer and the bar. So anything that uses any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualification or legal services, that would be considered as crossing the line of that the lines of propriety. Okay? Yeah, in this case, sinabi niya rito, he's an annulment specialist, which is, well, the court said it's unethical because it's self-laudatory, deceptive, and misleading. Sino nagbigay sa kanya ng title na yon, di ba? Moving on. Okay, solicitation. Based on the case of Director of Religious Affairs versus Bayot, it's highly unethical for an attorney to advertise his talents or skills as a merchant advertises his wares. Bakit? The law is a profession and not a trade. The lawyer degrades himself and his profession when he stoops and adopts the practices of mercantilism and advertising his services or offering them to the public. But again, going back to Khan versus Simbilio, there's a line. It must be proper and it must be compatible with the dignity of the legal profession. Okay? Now, what are the qualifications for admission to the bar? Sabi nga natin kanina, may mga educational requirement. Yun nga yung passing your college degree or secondary education, dapat completed na yan. Dapat completed mo na rin yung you have graduated and attained a degree in law, bachelor's of law or juris doctor, and then yun, pass the bar. Now for the non-academic qualifications, ito yung mga hindi din discuss masyado eh. Non-academic qualifications. First, you must be a Filipino citizen. Second, at least 21 years of age. Of good moral character, a resident of the Philippines, and must produce before the Supreme Court satisfactory evidence of good moral character. And he must not have any charges involving moral turpitude or anything that has been filed in any court in the Philippines. Okay? An examples ng cases involving moral turpitude, well, estafa is an example. Question. In his application to take the bar examination, Wolverine failed to disclose that he has 3 pending criminal cases. He also openly used the appellation attorney before passing the bar examinations. Should Wolverine be admitted to the bar? Answer, no. Ayan, ito nga pala yung gusto kong format ng mga sagot nyo, ha? Conclusion. Ibig sabihin, may reason na kaagad. Bakit? Okay? No, Wolverine should not be admitted to the bar because he concealed evidence of his questionable good moral character. By concealing the existence of such cases, Wolverine then flunks the test of fitness even if the cases are ultimately proven to be unwarranted or insufficient to impugn or affect the good moral character of the applicant. Okay. So nga natin yung sarili natin dito. Can you move? Can't move. Oh, I can. Okay. Let's go to the next one. What are the continuing requirements for membership of the bar? So, aside from those requirement before entering the bar before admission to the bar, meron ding continuing requirements for membership of the bar. Una, good moral character. Second, citizenship. Must continue to stay Filipino. Third, payment of taxes, professional tax, payment of membership fees, payment of IBP dues. Membership in the IBP and payment of IBP dues. Pag na-satisfy mo yan, you're considered as good and regular standing. And last, compliance with the mandatory continuing legal education, or MCLE. It's based on Rule 138, the Rules of Court. Okay, what is the consequence if a Filipino lawyer elects another citizenship? Answer is the loss of a Filipino citizenship, ipso iure, terminates one's privilege to practice law in the Philippines. Okay? May a lawyer who elected another citizenship be subsequently Again, may a lawyer who elected another citizenship but subsequently reacquired his Filipino citizenship be able to resume practicing law in the Philippines? The answer is yes. Yes, a lawyer who reacquires Filipino citizenship pursuant to Republic Act number 9225 can resume his practice of law, but he must first secure from the Supreme Court the authority to do so. Conditioned on, first, updating and payment of full Payment in full of the annual membership dues in the IPP. Payment of the professional tax, completion of at least 36 credit hours of mandatory continuing legal education to refresh the applicant's knowledge of the Philippine laws and update him of legal developments. Fourth is to retake the lawyer's oath, which purpose is what? To remind the applicant of his duties and responsibilities as a lawyer and as an officer of the court, and to renew his allegiance, his pledge of allegiance to the Republic of the Philippines. Okay. When may non-lawyers be allowed to appear in court? Question. Okay, here's the answer. Well, as a rule, only licensed lawyer may appear in courts. However, there are instances where non-lawyers may allow to appear in court first. Under the law student practicing a law student practicing under the Clinical Legal Education Program, or CLEP. Second, for civil cases before the first level courts, or MTCs, a party may conduct their own case or litigation in person with the aid of an agent or friend appointed by them for that purpose, or with the aid of an attorney. Again, for civil cases before any court other than the first level courts, a party may conduct their litigation personally or with the aid of an attorney. Their appearance must be either personal or by a duly authorized member of the bar. Now, for criminal cases, upon motion, the accused may be allowed to defend themselves in person when it sufficiently appears to the court that they can properly protect their rights without the assistance of counsel. Now, depending on the gravity of the offense and the difficulty of the questions that may arise in the localities where there are no members of the bar available, the court may appoint any person, a resident of such province and of good repute, for probity and ability to defend the accused. Another is any official or person appointed or designated in accordance with the law to appear for the government of the Philippines. Such a person shall have all the rights of a duly authorized member of the bar to appear in any case in which the government has an interest, direct or indirect. And last, non-lawyers may represent their parties in administrative tribunals such as the NLRC, the DARAB, cadastral courts, and the NCIP, or if they are designated as regional hearing officers. Okay. Based on the rules of procedure of small claims, LGC, Local Government Code, and the rules of the National Commission on Indigenous People. These are the proceedings where lawyers are prohibited to appear as counsels. Again, prohibited to appear as counsels. First, proceedings before the Small Claims Court. Second, proceedings before the Katarungan Pambarangay. Third, proceedings under the indigenous system of settlement for disputes involving indigenous persons, cultural communities, or indigenous peoples. Okay, who are the public officials who cannot practice law or can practice law but with some restrictions? Okay, those who are absolutely prohibited to practice law. There are 9. First, judges and other officials of the judges and other officials and employees of the Supreme Court. Second, officials and employees of the OSG, or the Office of the Solicitor General. Third, government prosecutors. Well, these are the prosecutors under the National Prosecution Service, under the DOJ. Fourth, President, Vice President, members of the Cabinet, their deputies and assistants. Fifth, members of the Constitutional Commissions. Sixth, officers or employees whose duties and responsibilities require that their entire time be at the disposal of the government. Seventh, Ombudsman and his deputies. Eighth, all governors, city and municipal mayors, unless those prohibited under special laws. This is based on Rule 138, Section 35 of the Rules of Court. Okay, who are those with limited restrictions? Those are the following. First, senators or members of the House of Representatives may not appear as counsels before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Second, Sangguniang members. They may practice their professions, engage in any occupation, or teach in schools except during session hours. Provided, however, that the Sangguniang member who are also members of the bar shall not, first, appear as counsel before any court or in any civil case wherein a local government unit or any office, agency, or instrumentality of the government is the adverse party. Second, they should not appear as counsel in any criminal case wherein the officer or employee of the national or local government is accused of an offense committed in relation to his office. Third, they should not collect any fees for their appearance in administrative proceedings involving the local government unit of which he is an official. D. Use property and personnel of the government except when the Sangguniang member concerned is defending the interests of the government. Okay, third group of government officers who with limited restrictions are retired justices or judges receiving pension from the government. As a rule, no retired judges or justices receiving a pension from the government shall act as counsel first in any case wherein the government or any of its subdivisions or agencies is the adverse party. In any criminal case wherein an officer or employee of the government is accused of an offense committed in relation to his office. And third, they cannot collect fees for his appearance in any administrative proceedings to maintain an interest adverse to the government, insular, provincial, or municipal, or in any of its legally constituted officers. Fourth group of government employees are, with limited restrictions, are civil service employees. They cannot engage in the private practice of law without permission from their department heads. And last, a lawyer shall not, after leaving government service, accept any engagement or employment in connection with any matter in which he had intervened while in the said service. Okay, primary basis of these restrictions, it's the 1997 Constitution and the Local Government Code. Okay. Who are the lawyers who are authorized to represent the government? Again here, the OSG, any legal officer of the LGU or the national government, and Office of the Government Corporate Council or OGCC. And again, I think that's it for the preliminary principles or basic principles of legal ethics. The second session will be on the CIPRA. Okay, see you in the next session.